Good day everyone. We are the Group 5. Together with my group members, Greggy Maceda, Rheill Salceda, Rigo Nan Caintoy, and I am Erven Ellevera. Today, we are discussing about the Corporation Code of the Philippines, Batas Pambansa bilang 68, Title 14 to 16.
Good day everyone, my name is Erven Ellevera. I'm going to discuss about Title 14, Dissolution. Section 117, Methods of Dissolution. A corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. So what is the meaning of dissolution? The term dissolution, as applied to a corporation, signifies the extinguishment of its franchise to be a corporation and the termination of its corporate existence. There are two legal steps in corporate dissolution. First, the termination of the corporate existence, at least as far as the right to go on doing ordinary business is concerned. And second, the winding up of its affairs, the payment of its debts, and the distribution of its assets among the shareholders or members and other persons interested. After winding up, the existence of the corporation is terminated for all purposes. Section 118, Voluntary dissolution where no creditors are affected. Dissolution of a corporation may be effected by majority vote of the Board of Directors or Trustees. Stockholders owning at least 2/3 of the outstanding capital stock required for dissolution. The Securities and Exchange Commission shall issue the certificate of dissolution. Next, Section 119. Voluntary dissolution where creditors are affected. The petition for dissolution of a corporation may be filed with the Securities and Exchange Commission. The petition must be signed by a majority of its Board of Directors or Trustees or other officers having the management of its affairs. It must set forth all claims and demands against it, and that its dissolution was resolved upon by the affirmative vote of stockholders. If the petition is sufficient in form and substance, the Commission shall, by an order reciting the purpose of the petition, fix a date on or before which objections may be filed. A copy of the order shall be published at least once a week for 3 consecutive weeks in a newspaper of general circulation. If no objections is sufficient, the Commission will render judgment dissolving the corporation and directing such disposition of its assets as justice requires. The Commission may appoint a receiver to collect such assets and pay the debts of the corporation. Next, Section 120. Dissolution by shortening corporate term. A voluntary dissolution may be effect by amending the Articles of Incorporation to shorten the corporate terms pursuant to the provision of this code. A copy of amended Articles of Incorporation shall be submitted to the Securities and Exchange Commission in accordance with this code. Upon approval of the amended Articles of Incorporation of the expiration of the certain term, as the case may be, the corporation shall be then dissolved without any further proceedings, subject to the provision of this code on liquidation. Section 121. Involuntary dissolution. A corporation may be dissolved by the Securities and Exchange Commission upon filing of a verified complaint and after proper notice and hearing on the grounds provided by existing laws, rules, and regulations. Section 122. Corporate liquidation. Every corporation whose charter expires by its own limitation or it's annulled by forfeiture or otherwise, or whose corporate existence for other purposes is terminated in any other manner, shall nevertheless be continued as a body corporate for 3 years after the time when it would have been so dissolved, for the purpose of prosecuting and defending suits by other against it, and enabling it to settle and close its affairs, to dispose of and convey its property, and to distribute its assets, but not for the purpose of continuing the business for which it was established. At any time during said 3 years, the corporation is authorized and empowered to convey all of its property to trustees for the benefit of stockholders, members, creditors, and others persons in interest. From and after any such conveyance by the corporation of its property in trust for the benefit of its stockholders, members, creditors, and others, another in interest. All interest which the corporation had in the property terminates. The legal interest vests in the trustees and the beneficial interest in the stockholders, members, creditors, and other person in interest. Upon the winding up of the corporate affairs, any asset distributable to any creditor or stockholders or member who is unknown or cannot be found shall be distributed to the city or municipality where such assets are located, except by decrease of capital stock and as otherwise allowed by this code. No corporation shall distributed by any of its assets or property except upon lawful dissolution and after payment of all its debts and liabilities.
Good day everyone, I am Ralph Greggy and Maceda and I'm going to report the Title 15, which is the Foreign Corporation of Batas Pambansa bilang 68 the Corporation Code of the Philippines. Section 123, Definition and Rights of Foreign Corporation. Foreign corporation is one form organized or existing under laws other than those of the Philippines and whose laws allow Filipino citizens and corporation to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining license for the purpose in accordance with this code and certificate of authority from the appropriate government agency. Section 124, Application to existing foreign corporations. Every foreign corporation which on the date of effectivity of this code is authorized to do business in the Philippines under the license issued to it shall continue to have such authority under the terms and conditions of its license, subject to the provision of this code and other special laws. Section 125, Application for a license. A foreign corporation applying for a license to transact business in the Philippines shall submit to the Commission a copy of its article of incorporation and bylaws certified in accordance with law, and their translation to an official language of the Philippines, English. If necessary, the application shall be under oath and unless already stated in its article of incorporation. It shall specifically set forth this following number 1 to 10. 1. Certificate under oath duly executed by the authorized official or officials of jurisdiction of its incorporation, attesting to the fact the laws of the country or state of the applicant allow Filipino citizens and corporations to do business therein, and that the applicant is an existing corporation in good standing. If the certificate is in a foreign language, a translation thereof in English under oath of the translator shall be attached the application, accompanied by statement or under oath of the president or any other person authorized by the corporation showing the satisfaction of the commission, and when appropriate, other governmental agencies, that the applicant is solvent and in sound financial condition, setting forth the assets and the liabilities of the corporation as of the date not exceeding 1 year immediately prior to the filing of the application. Note: foreign banking financial insurance corporations shall, in addition to the above requirements, comply with the provision of existing laws applicable to them. In the case of all other foreign corporations, no applications for license to transact business in the Philippines shall be accepted by the Commission without previous authority from the appropriate government agency whether required by law. Section 126. Insurance of a license. If the Commission is satisfied that the applicant has complied with all the requirements of this code and other special laws, rules, and regulations, the Commission shall issue a license to transact business in the Philippines to add to the applicant for the purpose or purposes specified in such license. Section 127. Who may be resident agent? A resident agent may be either an individual residing in the Philippines or domestic corporation lawfully transacting business in the Philippines. Individual resident agent must be a good moral character and sound financial standing. Domestic corporation as a resident agent, it must be likewise of sound financial standing and must show proof that it is in good standing as certified by the Commission. Section 128. Resident agent services of process as a condition to the insurance of the license for a foreign corporation to transact business in the Philippines. Such corporation shall file with the Commission a writing power of attorney designating a person who must be a resident of the Philippines. Right and responsibility of a resident agent. The resident agent is one whom summons and other legal processes may be served in all actions, or other legal processes may be served in all action or legal proceeding against such corporation. Whenever such service of summons or other process is made upon the commission, the commission shall within 10 days thereafter transmit by mail a copy of such common or other legal process to the corporation at its home or principal office. All expenses incurred by the commission for such service shall be paid in advance by the party at whose instance the service is made. It shall be duty of the resident agent to immediately notify the commission in writing of any change in the resident against address. Section 129. Law applicable. General rule are foreign corporation lawfully doing business in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class, exception those which provide for the creation, formation, organization, or dissolution of corporation, or those which fix the relations, liabilities, responsibilities, or duties of stockholders, members, or of officers or of corporation to each other or to the corporations. Section 130. Amendments to Article of Incorporation or bylaws of foreign corporations within 60 days after the amendments becomes effective. File with the Commission and in proper cases with the appropriate government agency a duty authenticated copy of the amendments article of incorporation or bylaw, indicating clearly in capital letters or underscoring that change made, duly certified by the authorized official or officials of the country or state in incorporation. Such filing shall not in itself enlarge or alter the purpose or purposes for which such corporations is authorized to transact business in the Philippines. Section 131. Amended license. A foreign corporation authorized to transact business in the Philippines shall obtain an amended license in the event it change its corporate name or desire to pursue other or additional purposes in the Philippines by submitting an application with the Commission favorably endorsed by the appropriate government agency in the proper cases. Section 132. Merger or consolidation involving a foreign corporation license in the Philippines. One or more foreign corporations authorized to transact business in the Philippines may merge or consolidate with any domestic corporation or corporations if permitted under Philippine laws and by the law of its corporation, provided that the requirements on merger or consolidation as provided in this code are followed whenever a foreign corporation authorized to transact business in the Philippines shall be party to merger or consolidation in its home country or state permitted by the law authorizing its corporation. Such foreign corporation shall within 60 days after the effective of such merger or consolidation file with the Commission and in proper cases with the appropriate government agency a copy of the article of merger or consolidation was effective provided, however, that if the absorbed corporation is the foreign corporation doing business in the Philippines, the latter shall at the same time file petition for withdrawal of its license in accordance with this title. Section 133. Doing business without license. General rule. No foreign corporation transacting business in the Philippines without license or its successor or assigns shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines, exception. The corporation may be sued or proceeded against before the Philippine court or administrative tribunals on any valid cause of action recognized under Philippine laws. Doing business means one single or isolated business transaction does not constitute doing business. There must be continuity of conduct and intention to establish a continuous business, such the appointment of the local agent and not one of temporary character. It simply implies that doing business is a continuity of commercial dealings and agreements and contemplates the performance of acts or works or the exercise of some functions normally incident to the purpose and object of its organization. Section 134. Revocation of license. The license of foreign corporation to transact business in the Philippines may be revoked or suspended by the Commission upon any of these following grounds stated on this slide. Section 135. Insurance of certificate of revocation. Upon the revocation of the license to transact business in the Philippines, the Commission shall issue a corresponding certificate of a revocation, furnishing copy thereof to the appropriate government agency in the proper cases. The Commission shall also mail the notice and copy of the certificate of revocation to the corporation and its registered office in the Philippines. Section 136. Withdrawal of foreign corporations. A foreign corporation license to transact business in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of the license. No certificate of withdrawal shall be issued by the Commission unless all these following requirements stated in the slide are met. Thank you.
Good day everyone, I am Jhon Salceda and I am the reporter of Section 137 to Section 143 and Section 149. Section 137, Outstanding Capital Stock defined. The term outstanding capital stock as used in this code means the total shares of stock issued under binding subscription agreements to subscribers or stockholders, whether or not wholly or partially paid, except treasury shares. So matud pa sa Section 137, ang mga capital stock nga gigamit sa code ini kay nagatutok daw sa mga nagbuo nga issue sa mga subscriber o stockholder, then dapat buo ang mabayaran pero dili na iapil ang mga gipang treasury share. So Section 138, designation of governing boards. The provisions of specific provisions of this code to the contrary, notwithstanding, non-stock or special corporations may through their articles of incorporation or their bylaws designate their governing boards by any name other than as Board of Trustees. Designation of governing boards sa Section 138 man to. So lahi na mga gipang bawal sa mga particular na provision nga gikan sa kodigo niining Section 138. Then ang mga non-stock o mga special na corruption kay pwede sab sila makasuggest o ilang kaugalingong artikulo nga dili gikan sa ilang lupon. Sumpay. So Section 139, Incorporation and Other Fees. The Securities and Exchange Commission is hereby authorized to collect and receive fees as authorized by law or by rules and regulations promulgated by the Commission. So ayun pa sa Section 139 nga ang mga bayronon kay giusa sa serbisyo. So ang mga securities kay Exchange Commission sa pagitan ini din gipang tagaan og mga katungod nga magkolekta or mudawat sa mga bayronon pamaagi sa batas o sa mga tuntunin ng komisyon meaning Section 139. So ito siya. Then Section 140, stock ownership in certain corporations. Pursuant to the duties specified by Article 14 of the Constitution, the National Economic and Development Authority shall, from time to time, make a determination of whether the corporate vehicles has been used by any corporation or by business or industry to frustrate the provisions thereof or of applicable laws, and shall submit to the batasang pambansa whenever deemed necessary a report of its findings, including recommendations for their prevention or correction. Maximum limits may be set by the Batasang Pambansa for stock holdings and corporations declared by it to be vested with the public interest pursuant to the provisions of this section, belonging to individuals of group or groups of individuals related to each other by consanguinity or affinity or by close business interest, or whenever it is necessary to achieve national objectives, prevent illegal monopolies or combinations in restraint or trade, or to implement national economic policies declared in laws and regulations designed to promote the general welfare and foster economic development. And recommending to the Batasang Pambansa corporations, businesses, or industries to be declared vested with the public interest, and in formulating proposals for limitations on stock ownership, the National Economic and Development Authority shall consider the type and nature of the industry, the size of the enterprise, the economies of scale, the geographic location, the extent of Filipino ownership, the labor intensity of the activity, the export potential, as well as other factors which are germane to the realization and promotion of business and industry. So, continue tayo sa Section 141, Annual Report of Corporations. Every corporation, domestic or foreign, lawfully doing business in the Philippines shall submit to the Securities and Exchange Commission an annual report of its operations, together with the financial statement of its assets and liabilities, certified by any independent certified public accountant in appropriate cases, covering the preceding fiscal year and such other requirements as the Securities and Exchange Commission may require. Such report shall be submitted within such period as much as may be prescribed by the Securities and Exchange Commission. So, yun na yun nga, ang lahing korporasyon, mga domestic o dayuhan daw nga nangaligal o negosyo sa Pilipinas, kaya dapat magsumiti sa Securities and Exchange Commission sa mga kadatuig nini. Apil na po na nilang mga ari-arian o mga official statement, dahil kumatuod na sa kinsa mo na dapat yun daw mawagi sa korte basta mga dayuhan o mga domestic. Section 142, Confidential Nature of Examination Results. All interrogatories propounded by the Securities and Exchange Commission and the answers thereto, as well as the results of any examination made by the Commission or by any other official authorized by law to make an examination of the operations, books, and records of any corporation shall be kept strictly confidential, except insofar as the law may require the same to be made public, or where such interrogatories, answers, or results are necessary to be presented as evidence before any court. So, ito siya, dapat din daw nga pribado ang mga pagsusulit nga resulta sa mga tugon sa Securities and Exchange Commissions, din apila sa mga resulta sa mga lain-lain gikan sa komisyon o sa mga lain pang opisyal na gisugo pagpahintulot nga suri ng operasyon. Then ang libro ang mga talaan ng isang korporasyon apila na, then dapat jud nga higpito ng confidential maliban kung kinahanglan nga i-public sa batas para himuon kining ebidensya. Section 143, Rule making of the Securities and Exchange Commission. The Securities and Exchange Commission shall have the power and authority to implement the provisions of this code and to promulgate rules and regulations reasonably necessary to enable it to perform its duties hereunder, particularly in the provisions of fraud and abuses on the part of the controlling stockholders, members, directors, trustees, or officers. And Securities and Exchange Commission, so, muto sila, stockholders, members, directors, trustees, or officers. So ang Securities and Exchange Commission kay dapat may kapangyarihan o mag-otoridad nga igibuhat ang provision sa kodigo niini. Dapat nagidi kung may power o ipahayag ang mga tuntunin apil na pod ang regulasyon nga makatwiran nga kinahanglan para mabuhat niini ang responsibilidad para po daw nga makalikay sa pandaraya o abuso sa mga lumoto, stockholder, membro, director, apil na po ng mga opisyalis.
Section 144. Violations of the Code. Violations of any of the provisions of this code or its amendments not otherwise specifically penalized therein shall be punished by a fine of not less than 1,000 pesos but not more than 10,000 pesos, or by imprisonment for not less than 30 days but not more than 5 years, or both, in the discretion of the court. If the violation is committed by a corporation, the same may, after notice and hearing, be dissolved in appropriate proceedings before the Securities and Exchange Commission, provided that such dissolution shall not preclude the institution of appropriate action against the director, trustees, or officer of the corporation responsible for said violation. Provided further that nothing in this section shall be construed to repeal the other causes for dissolution of a corporation provided in this code or of any part thereof. Section 145. Amendment or repeal. No right or remedy in favor or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred by any such corporation, stockholders, members, directors, trustees, or officers shall be removed or impaired either by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of this code of any part thereof. Section 146. Repealing clause. Except as expressly provided by this code, all laws or parts thereof inconsistent with any provision of this code shall be deemed repealed. Section 147. Separability of provisions. Should any provisions of this code or any part thereof be declared invalid or unconstitutional, the other provisions, so far as they are separable, shall remain in force.
Section 148. Applicability to existing corporations. All corporations lawfully existing and allowed and doing business in the Philippines on the date of the effectivity of this code and heretofore authorized, licensed or registered by the Securities and Exchange Commission shall be deemed to have been authorized, licensed or registered under the provisions of this code, subject to the terms and conditions of its license, and shall be governed by the provisions hereof, provided that if any such corporation is affected by the new requirements of this code, said corporation shall, unless otherwise herein provided, be given a period or not more than 2 years from the effectivity of this code within which to comply with the same. So matod pa sa Section 148 kay mga negosyo nga applicabilities sa tanan nga korporasyong legal nga nagapamatuod daw nga sa mga nagnegosyo sa Pilipinas nga naibisa sa mga code niini, mga karaang otorisado, lisensyado o nakarehistro sa Securities and Exchange Commission, kaya dapat ituring gid nila niini nga inana sila kaya aron makaproyba gid sila sa ilang lisensya niini nga kudigo din kung unsa man daw ang mga bagong reorganisasyon dapat pamahalaan jud sa provision ini agion jud. So mga karaan mo to sila. Then Section 149, effectivity. This code shall take effect immediately upon its approval. So mo to siya effectivity, kini nga code kay dito sumo epekto sa approval para sa kodigo nini. So that's all for the report. And Section 137 to 143, appeal na po ang 148 day, then ang 149. Thank you.